Guys, I have watched a lot of trials over the past 4 years. Ever since I became a LawTube junkie, it's like I'm constantly watching trials, right? And the attorneys that cover these cases, I've learned so much from. I've put together a compilation of some of these attorneys that I've been following, namely Uncivil Law, Runkle of the Bailey, Andrea Burkhart, Rob from Law&Lumber, and of course, Emily D. Baker, Melanie Little. And one thing that I noticed, this Karen Reed case has them all saying the same things. I've never seen them all agree on the same things. These attorneys are all different walks of life. We've got, civil litigants, we've got defense attorneys, we've got appellate attorneys, we've got former prosecutors, we've got family law. We even have attorneys in Canada. Shout out to Runkle. I mean, they all feel the same way about the bias that Judge Bev Cannone has in the case against Karen Reed. And so some of them just say it right outright. And this is like, they laughed, they cried, it's better than cats. Any of you Gen Xers know what I'm talking about? I mean, literally, some of them laugh. One of them is almost brought to tears. And there's a lot of, I don't know, they're getting pissed. So just wanted to share this with you. And in case you don't watch LawTube, these are some of my favorites. And this is what they've been saying.
Yeah.
Karen Reed is on the vehicle as they walk around it taking pictures. Why they didn't do any of this, why they're using solo cups. Like, when I started watching it, I was,
it's Morrissey is bringing this because he can't run away from the people who think she's guilty. If I'm looking at this and exercising my independent judgment, do I think I can prove this beyond a reasonable doubt? No fucking
You're
way.
being really generous with the misconduct. Like, really generous.
No way. Get me out of this case. No way.
So here's what happens, okay? They show up on the scene eventually.
Ian, take one of the experts. Any one of them. Pick one. ARCA, cell phone, dog bite. If you halfway believe one of them, 3 different topics, one of them, you can't convict.
Well, and the other thing
the blood sample, the alleged blood samples with red Solo cups, they put them in an open grocery bag in the back of the patrol car, drive said red Solo cups back to the Sally Port and leave them in the Sally Port so that the cups with the blood are sitting right next to her vehicle by the time they come and take the vehicle. So so forget about anything with cross-contamination. And this, you left out the best.
I agree. Motion granted. Motion granted. Code red.
Motion granted. All of you. I have granted the motion.
Part, the leaf blower. Okay.
Oh, yes.
So as they're collecting these red drops of blood, they decide to go borrow a neighbor's leaf blower, and they come and they leaf blow.
The fuck was that?
Did they even take pictures of where the body was?
Stop a second. Are they leaf blowing to melt the snow or to blow the snow away?
To blow the snow
blow
away.
The snow away. Let there's snow.
And leave the pool.
I can't even use this voice because I'm too mad. Like, I'm so mad.
Oh my God.
And what was the date? 10/10/24 you received that? Was that the date?
Congealed blood part?
Yes, and collect it with the red Solo cup. You're hearing this right.
And now I'm going to ask an obvious, stupid question.
I'm not going to make it to this trial. I have trouble enough making it through the motions. No, this is not how the practice of law is supposed to look at all, in the slightest, in any respect.
Were the red Solo cups used from the party from the night before?
How she came to possess them at the time, but she did write on that little pad, quote, "That is how it records, LOL, no tampering," end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations.
I told y'all, when my gut says we can't go to code red yet because more fuckery might pop off, we're always going to trust it, because a note from the desk of that says this is how it records LOL is not what I had anticipated.
I mean, I don't know why this trial is still going on. So
today we are going to be talking about one of the most obvious illustrations of judicial bias I have seen in a long time. It is comparing apples to apples, and I find it hard to believe that it was this obvious and not even trying to hide it at this point. And yes, we're talking about Judge Cannone in the Karen Reed case, as Dr. Crosby is allowed to testify as an expert.
It is atrocious. It is atrocious that we can't get rid of this judge.
So I've kind of been like, I want to see an order
that really shows me that there's just judicial bias here. And I haven't seen it. And then this order comes out, and it's really becoming a lot harder for me to defend my position here that Judge Cannone is not biased. And
you're supposed to engage in the practice of law, not just because you're just being an asshole and throwing the other one under the bus. It's just a terrible example of what the practice of law is supposed to be. Just make your arguments. Attack the other side's arguments. This bullshit, underhanded nastiness. Unless he attacks the logic and methodology of the expert and goes after the expert and brings in the expert's thesis from when they were masters of student in 2016. But make it about the fucking practice of law, like actual practice of law. Don't sit there and just throw shit at the wall and throw shit at each other and let that stand.
Judge Cannone issued an opinion, pretty lengthy opinion, in where she called this a close call. There was a close call whether Dr. Russell was able to testify, whether she's qualified and whether her methodology is sound and could go to a jury. And she said it was a close call. And a lot of people had some issues with it. I didn't think it was a close call at all. But that's what she called it. She called it a close call. So now let's compare that to what happened with Dr. Crosby.
So what happened? What happened? What was the result? What's the ultimate disposition? This is the ultimate disposition because this came out today. After hearing and reviewing the pleadings, the court finds the Commonwealth has satisfied the foundation requirements of Daubert-Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony, principles, and methods employed are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility. Judge Cannone, the defense motion to exclude the testimony of James W. Crosby, master's PhD, is denied. This is just amazing to me. The different standards that are applied to both sides.
I don't like this. I don't like this order. I mean, I don't like it just because it doesn't really explain its own rationale, which is annoying.
It's a very thin order for sure.
That's what Robert Leslie's argument was, that this shouldn't even get to a Daubert-Lanigan hearing. And I thought his argument was pretty strong. I thought that, in fact, after listening to everything that happened in court that day, it did not seem at all that he's qualified or that he has methodology to be able to go in front of a jury as an expert on this topic and be able to tell the jury that these injuries were not from a dog.
And that you must be a medical doctor to testify as to causation of injuries in Massachusetts.
That was my understanding, yes.
And I mean, I'm like, okay, cool. Okay, if you're just applying the law, great. Like,
yeah, well, even the Commonwealth during their oral argument said they weren't aware of any such law. So just Aunt Bev was making it up. But even then, even if she was just making it up, it still might be okay, as long as she was going to apply, as long as she was going to apply it both ways. And that's more the problem here.
That's the problem, is so long as she's actually going to apply it, evenly.
In fact, what my research has shown is that there is no Massachusetts case that I've seen that allows anyone who's not a medical doctor, not a veterinarian, or a forensic odontologist to testify about causation of dog bite wounds. No one's able to find a case where it says anyone who is not a medical doctor, a veterinarian, or a forensic odontologist could testify about causation of dog bite wounds. So that's number one, that simply he's just not qualified. He may be qualified to talk about dog behavior, which seems to be his expertise, about whether a dog is acting aggressive or if he's acting calm, or what's going to happen with a dog when he acts a certain way. That may be his expertise. But to actually opine about causation of an injury, I've never come across anyone who's not a doctor who's able to testify about that.
Here's the point. Not a single bit of this has to do with Karen Reed so far. If I'm being honest, this could be John Smith. This could be Peter Tragos. This could be Brian Koberger. This could be R. Kelly. This could be P. Diddy. I don't care if it's Karen Reed or anybody else. I would feel the same exact way about these arguments. The knowledge about the Sallyport videos, the source was Trooper Michael Proctor. That is the prosecution team. So to act like you didn't know it existed, and Higgins, I don't know what Proctor said at the grand jury proceeding, but we know that Higgins, in his testimony, said there's a video of it, so Higgins knew there was a video. So all these cops want to try to say the video exists to try and bolster their credibility, yet they won't just give it to the defense to see what actually happened.
The first 48 hours of an investigation are absolutely critical, correct?
Objection.
Do you know that, sir?
Why wouldn't she just allow him to ask this question? Why is Lally objecting? It's perfectly legitimate line of questioning. And so for the judge to then asking the officer on the stand to answer the question for her, she's just taken away the effectiveness of the defense counsel. And her being a long-term public defender doing this kind of stuff, it's just very much disturbing to see.
Cops can't use video as a sword and a shield. There's video of it. So a juror listening would be like, oh, okay, well, he's obviously not lying if he knows there's a video camera there. That's using it as a sword. And then saying, well, you can't prove the condition of her taillight. Video doesn't exist. We purged it. It's blurry. It skips. That's using it as a shield against potentially bad evidence. That's what I don't like.
I mean, to put it quite frankly, it's completely ignoring the human factor. It's just simply for requiring the defense to be perfect. And this wouldn't, of course, necessarily be such a problem in and of itself if the judge was equally hard on the prosecution. because, you know, there's
maybe, you know, could have worded things better in his motion or in his sidebar or something like that, and like spelled all of that out in greater detail. Well, it wasn't relevant at all to the point that was being made in those particular motions. But that's essentially the argument. That's the wrongdoing that's being alleged against Alan Jackson. And it was so outrageous that, you know, Judge Bev is, or,
she was literally like shaking. Like,
yes,
it was just,
and
I thought she was going to have like a stroke.
Grave concern.
So the Commonwealth just provided the court with information that causes me grave concern. The implication.
Now you're gravely concerned? Anybody else anxious? Anyone else anxious? Anyone else anxious?
Could seriously affect the defense and so forth. And so much that we have to, you know, come back and have a special hearing on it.
And a lie unchecked becomes the truth. So the fact that that hung out there for a week when Brennan got up there and absolutely 100% lied to the court when he said, we had to get all of this from the feds. And he can't say that he was mistaken because there was an entire monologue leading up to it that was building up to this whole thing. And then after she takes her time out for half an hour and comes back shaken, he's like, oh, I'd like to just, straighten out some chronology, right? Chronology. He did not say, I need to correct the record, Your Honor. I'm sorry. I need to correct the record.
You're not doing your job. I'm sorry. I get it. I understand that you're angry, but part of it is
yes, but if she
disposition
can't
here.
do her job at that point because she's angry,
then
her
judicial
responsibility is to not do
stop
it
the
right
proceedings. But then stop the proceedings and don't take the material back in chambers and review it. Leave the material at your bench. Because that's the problem. She suspended proceedings and took the shit back with her in chambers and reviewed it. I have a problem with that because that's one side of certain materials. That's a half image that she's now reviewing separately after listening to one side of the argument in chambers. No response. One, Brennan should have been up there at the fucking podium making the correction before she started talking, have the balls and cut her off and say, I'm sorry, Judge, I made a misrepresentation about the source of these materials. And instead, Brennan waits till she's halfway done with her monologue and then says, I have a correction on timing. Fuck off, Brennan. Kidding me. That's not a misrepresentation on timing. That is the source of the materials which form the entire crux of your argument. But that pissed me off.
Wow. What a nothing burger. So if I didn't get a chance to hear Brennan speak in open court, and allow me to be the first to say, if you haven't heard it anywhere else first, the dude is a slime bag. I mean, he is so conniving. He is so disingenuous and dishonest and so many.
That's quote certified weather statement.
What the hell is a certified weather statement? What is a certified weather statement? Is that a real thing? Do we use that in cases? I have never seen this in my life. Hang on. I gotta look this up now. I have to look this up immediately. What the fuck is a certified weather statement? Hang on. This is real? Jurisdiction. Let's just limit it to my state. What the fuck is a certified weather statement?
I'm anxious. Now there's grave concern?
I don't know how the accent reconstruction video has anything to do with what we're talking about right now. That doesn't make any sense. We're talking about the condition of the taillight. How does the accent reconstruction video help us understanding that? I don't know how it's relevant to what we're talking about right now. Pressing on. The Commonwealth has provided some beyond unsupported claim and vague innuendos. The defense struggles to establish exactly how the condition defendant's broken taillight at Canton's Police Department Sallyport is in fact exculpatory or the most critical and highly contested issue of the case. Well, I mean, I would agree that's not necessarily the most highly contested or most important issue. I mean, I'm not going to go to the wall fighting you on that. If you think that there are other issues that are more important than that, I won't go to the wall fighting you on that. The thing that I'm going to fight you on more is whether or not physics is a thing. That's the most important issue to me. Are physics still a thing in Canton? So I suppose I disagree with the defense. The most important thing is not whether the tail light was intact. The most important thing is what is physics, and also its related question: how long to die in
documents
coal?
found in any cases in Virginia. No, now I'm going to expand my search. I need to find out if this is real. We're not limiting our search. We're searching all jurisdictions. I'm not finding this word anywhere except in a news article.
Completely shattered, completely whatever, which, you know, would help the state's case, or it's none of those things, or not all those things, in which case it would help the defense's case. So how does the condition relate to the exculpatory nature? You really have to figure that one out. I mean, seems kind of self-evident, but, you know, okay.
Paying plows by inch, not by the hour, can save a city's snow budget. This is it's the Boston Globe.
Their production, the prosecutor was unaware. It seems like you're unaware of a lot of things, prosecutor. It's not a good look. It's not a good look. Right? How many things do you think we should explain away before we're like, maybe something's rotten in the state of Denmark? Right? That's sort of my question here. Back to them. It's like, just how many things do you want us to hand wave away and give you grace for before we're like, you know, maybe there's a bigger problem here? I mean, trials, you know, to be fair to the Commonwealth, and, you know, trials everywhere. Trials are not perfect. Trials are not perfect. Mistakes are made. You know, people are human. There is a human factor and all the rest of it. So, you know, we can extend some grace to people. I'm not beyond extending grace to people. But it's just like, how much grace do you want here, man? You're asking for a lot. Between all the things with the solo cups and the logs missing and the evidence floating around in someone's trunk for a month and leaf blowers and rakes and so many things. It's hard to even know how long to die. It's how much stuff do you want me to ignore here, man? It's a long list.
Parties waited anxiously yesterday for a quote certified weather statement from Hull-based New England Weather Science to determine official snowfall from Sunday's huge storm. Okay, so it is a thing. It looks historically at what transpired that day weather-wise. So it's a certification that the weather was.
It's abhorrent that we have to tolerate such
You mean
corruption.
to say, hold on, Mr. Alessi. You mean to say that Adam Lally could have hired a meteorologist to provide a certified weather statement and we could have bypassed 9 fucking witnesses testifying that it was snowing? You mean we could have gotten a certified weather statement to say it was snowing that day? I'm a certified meteorologist.
Federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications.
He couldn't be clearer that it is closed. It is over. And we talked about this in the past about how the feds handle investigations, especially something as sensitive as this. They don't always tell you, nor do they have to tell you, if you're a target, what they're investigating, who they're investigating.
That was a very, very interesting email/letter that really didn't tell us anything. Secondhand information.
If I was the defense, I wouldn't believe it till I saw it in writing because of the problems they've had with the prosecutor's office.
Somebody unknown at the feds told this, what's her name, Jafferty or whatever, that, oh, we're done. But I want to see that in a court document before I believe it.
Right.
From the feds themselves. It's weird. Very evasive.
Here, they did not actually make the disclosure. They told this prosecutor that it was closed, and they told him, you have permission to say it. They themselves never actually have come out and said it.
Yeah,
I think that's an interesting.
And this just, there's something wrong here.
You just say it like that. I want something from the court. Why court?
But because then you have the acknowledgement, then even if it is from Judge Bev, yes, I have received this email, I have concluded that the information here is correct. Then you have, then also you go from somebody just say transferring information to somebody. Okay, now there's transfer of information that brings a legality to it. But nobody actually shows that document. And it is more of this, unless it's a sworn affidavit.
Right, right.
You risk nothing without, if you don't, have your signature to it, your actual signature, that under the penalty of perjury, this is the information I will relay. Without that, it's just gossip.
Who is the speaker? The speaker is the entity being investigated, who has a vested interest for the investigation to be concluded.
Yeah.
Yeah.
The feds can lie.
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problem.
Oh shit, he grabbed the binder. What did he go grab? Like, oh shit, he went back to his table and grabbed the binder. Every lawyer knows that move. Like, we all know that move. It's like, I have this one fucking thing I've been waiting to pull out.
Freeze-thaw effects on penetrometer resistance and shear strength.
Penetrometer?
Penetrometer? The fuck is a penetrometer?
I'm just gonna say that
What
sounds
is
wrong.
That? What is a penetrometer?
It's apparently for measuring pennants.
God. Oh my God. A device that no man wants to hear about ever, ever, ever.
She's like, you think you did a good job, but let me pull out the penetrometer.
Let's go to the penetrometer replay.
Now I'm imagining it as like one of those like bar games, like the thing that you like those things that you punch, and it's got the meter.
And the big dude walks up and he's like, let's see how he did, folks. What does the penetrometer say? No. This is a real device. Oh my God.
X on penetrometer resistance and shear strength.
Was that just a Google search? I saw that you had it on here.
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science for geology, Dr. Don.
Wow.
Hank Brennan has a fucking weatherman, and he's like, I consulted with the former head of the National Academy of Science for Geology.
He's like, no. Let him stay on. But I want to make sure that the court is aware of the deceptions that were put before you. They failed to correct them. They failed to address them. They went viral. The media is now involved. The jury pool is being tainted. But despite all of that, he says, let's continue moving forward. What a guy. I am absolutely stunned. I can't even find the words. This kind of lawyer work doesn't exist anymore. I thought it was extinct. Wow. It makes a lawyer want to weep. I'm not kidding. I almost have tears in my eyes. How impressed I am. That was spectacular.
Standing was outside doing crowd control, some other BS, and made all of these statements of fact, but did not attach an affidavit from Fanning.
Mm-hmm. Yeah.
In what world is that acceptable?
In Judge Cannone's land, it was the same thing in Delphi. It was the same thing that we would run into Delphi. You would have attestations from the prosecuting attorney, and they would be accepted as true because, you know, that's the lack of the even playing field. The defense is not going to be able to do that. When the defense tries to do that, they're going to be, you know, chastised for it, or they're going to be like accused of being unethical for it.
Right.
But let the Commonwealth do it, and there, you know, suddenly doesn't seem to be a problem. It's one of the mind-blowing things about where we're at right now.
Wait a second. Why is he going to go again? I don't understand this courtroom. I don't get it. The person who makes the motion gets the last word. That's the rule. This courtroom is bullshit. Oh my God. This is the worst example of how trials are supposed to happen.
That case has fallen off the freaking rails.
It's been falling off the rails for quite some time, but yes.
Oh, but I mean, it has fallen off the rails and exploded.